All right, good morning, all. The meeting.
On a sad note,
Mr. Trogman. There he is. Is
Morning.
anybody signed up for public comment?
We do not have anyone registered for public comment this morning.
Thank you very much, sir. Good morning, Ms. Miller.
Good morning, sir.
Let's see, how are you today?
I'm doing very well, thanks.
Well, that sounds good. You sound excited to tackle this docket for us.
Yes, sir.
Oh, I love it. On agenda item 3, however, we have no cases to reconsider. Is that correct?
That's correct. No cases.
Tax liability cases on agenda item 4. I think we do have one tax case on docket 4.
Yes, sir. We have case number TD-20-086-0820. Commissioner Demerson,
Agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation. All right, on agenda item 5, no fair housing cases.
That's correct.
Okay, agenda item 6, there's no wage claim cases that have been pulled for additional discussion.
Yes, sir. That's correct. I did just send you the wage claim short form dissent list for docket 4.
You sure did. I move we accept staff recommendations on the remaining wage claim cases on docket 4.
I second the motion except for those cases on which I'm dissenting, as reflected on the wage claim short form dissent list for docket 4.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the wage form dissent list for docket 4.
The motion passes with the exceptions.
Thank you.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 4. Please proceed when you're ready.
Thank you.
2534910, Commissioner Alvarez.
The decision should be modified. No misconduct, no chargeback due to disaster, sever validity of claim, and void adequate response. The employer was experiencing a reduction in business due to the pandemic and offered employees the opportunity to go on furlough if they had COVID safety concerns. The claimant is diabetic, which puts him at a higher risk for COVID-19 complications. As the claimant was already working reduced hours due to the business slowdown, he accepted the offer furlough to protect himself from COVID-19. Therefore, as the claimant was separated due to the pandemic, he should be qualified for benefits and the employer's account should be protected from charge. Modify the AT, no misconduct, no chargeback due to disaster, sever validity of claim, and void adequate response.
I'm going to agree with Commissioner Alvarez. The AT decision should be modified. I agree that the claimant's separation was the result of the disaster. The claimant should be qualified for benefits and the employer's account protected from charge. Modify the AT decision, no misconduct, no chargeback, disaster, sever the validity of claim ruling, and void the adequate response ruling.
Modify the AT, no voluntary leaving, no chargeback, disaster, void adequate response, sever validity claim issue.
All right. We have a majority vote to protect the employer and grant benefits to the claimant based on disaster. I did just want to point out, Mr. Chairman, that the majority vote is a misconduct vote, and not a quit voluntary leaving vote.
Okay.
Thank you.
Case number 2588576, Commissioner Demerson.
The AT decision should be reversed. The claimant was discharged following a complaint that she mishandled a child while on duty. The owner of the business testified that she watched the video firsthand and saw the claimant pull a child by one arm, which could have harmed the child. Although the claimant denies the allegations, she had a prior warning for similar conduct, and her denial is self-serving. Furthermore, the claimant declined to view the surveillance footage of the incident when the employer offered her an opportunity to do so. Thus, the claimant's denial is not persuasive, and we should reverse the AT decision. Misconduct, no chargeback, adequate employer response. In the alternative, I would agree to a vote of no misconduct, no chargeback. Separation was urgent, compelling, and necessary since the claimant worked with children and the employer could not reasonably continue to employ the claimant once the allegations were verified by the owner of the company.
The AT decision should be affirmed. The claimant was discharged for allegedly grabbing a child inappropriately by the arm. The claimant has consistently denied the allegations. The employer has only provided secondhand evidence of the incident. Even though the employer was given yet another opportunity to submit photographic, or video evidence, the employer has chosen not to do so. Since the claimant has consistently denied inappropriately grabbing the child, the employer has no firsthand evidence of its allegations. The employer failed to meet its burden to establish the claimant misconduct by preponderance of the evidence. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form.
Yes, sir, Commissioner Dimerson.
Thank you.
Case number 2609471, Commissioner Alvarez.
The AT decision should be modified. I agree with the AT that the claimant filed a valid claim and that the employer was a party of interest. On the separation, the claimant is a diabetic, which made him vulnerable to a serious illness if he contacted COVID-19. Moreover, the employer was not adequately enforcing safety measures, such as the use of protective equipment and masks. The claimant therefore had good cause connected with the work to leave the job. Modify the AT valid claim, employer is a party of interest, no voluntary leaving.
The AT decision should be modified based on the claimant's job and his medical condition. I would agree that he should be qualified for benefits due to the disaster. Accordingly, we should modify the AT decision, no voluntary leaving, separation due to the disaster, sever valid claim issue.
I concur with Commissioner Dimerson.
Commissioner Alvarez, do you want to dissent or
Yes,
not?
short form dissent on this one.
Yes, sir, I have that.
Case number 2615327.
That's Commissioner Alvarez.
Yes, ma'am. The decision should be reversed. No misconduct. The claimant missed work because he was exposed to COVID-19 and was sick. He complied with the employer's notice policies. A Dallas County judicial order stated that employers should not require a negative COVID test or a medical note before allowing recovered employees to return to work, and also stated that employers should not take adverse actions against employees who quarantine. There was still a limited supply of tests available at the time, and many healthcare providers did not want patients with COVID symptoms coming in unnecessarily. The claimant had followed the recommended advice and stayed home, but did not see a doctor. As the claimant followed the employer's recommendations, stayed home, and followed the county judicial guidance, his actions were not misconduct. Reverse AAT, no misconduct.
The claimant's disqualification from benefits is appropriate. The claimant filed his additional claim over 2 weeks before the employer considered the claimant to have been discharged. Thus, the claimant resigned when he stopped reporting to work and filed a claim for unemployment benefits. Since the claimant did not make an adequate effort to protect his job before filing for benefits, he quit without work-connected good cause. If viewed as a discharge, the claimant's failure to provide the employer with the requested medical documentation would constitute work-connected misconduct. In addition, the Dallas County order does not apply to this case, since it only applies to COVID-19 recovered employees. By the claimant's own admission, he never visited a doctor, nor did he ever get tested for the virus. Under these facts, we should affirm the AT decision, voluntary leaving.
Modify the AT, misconduct.
Short form dissent.
All right. Your secondary vote was misconduct. Is that correct, Commissioner Dimerson?
Yes, I had voluntary leaving, but we're okay with misconduct.
Thank you, sir. And I have your short form dissent, Commissioner Alvarez.
Thank you.
All right, case number 2621899, Commissioner Alvarez.
The decision is not supportable. The claimant, who worked for the employer for 15 years, has diabetes and had a stroke a couple of years ago prior to his separation. The claimant frequently needed to sit. The claimant's former supervisor testified on his behalf that it is a common knowledge among management that the claimant required accommodations for a disability. A new store manager removed the desk and chair that the claimant used. A coworker testified that she heard the claimant explain to the manager that he needed the accommodation. The claimant provided new medical documentation to the employer regarding the need for the accommodation. The employer still failed to provide accommodation. Over a month later, the manager still claimed to have no idea that the claimant required accommodation. The employer's failure to provide reasonable accommodation for the claimant's disability provided him good reason for quitting. Reverse the AT, no voluntary leaving chargeback.
The AT decision should be affirmed. The claimant's testimony is questionable because it conflicts with his fact-finding statements. Since the claimant initially stated that he quit despite the employer's agreement to accommodate him, we should affirm the AT decision, voluntary leaving, no chargeback.
Reverse the 18, no voluntary leaving chargeback.
Short form.
Yes, sir, Commissioner Demerson.
Case number 2627650, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant was fired for allowing an inmate to draw blood from another inmate. The claimant alleged that he was given permission to do this by an on-duty officer. However, the employer stated that the officer who allegedly gave the claimant permission to do this was not medically trained and had no supervisory authority over the claimant. The claimant contends that he was let go for retaliatory reasons and that he never received any policies from the employer. However, the act of a licensed medical professional delegating an invasive medical procedure to an inmate of a correctional facility is not an act that is in the employer's best interest. As such, the claimant's actions constituted work-connected misconduct. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant for allegedly violating the employer's policies. The employer did not provide the violated policies to the commission and was unable to testify to what actually was said. The claimant has denied receiving policies from the employer, and the employer failed to provide the claimant acknowledgement form. Additionally, the action for which the claimant was discharged was performed after he received permission from an officer. The employer has failed to provide sufficient evidence to establish misconduct connected with the work. Affirm the AT, no misconduct chargeback.
Affirm the AT, no misconduct chargeback.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2628786, Commissioner Alvarez.
The decision is not supportable. The claimant filed a valid initial claim, and her claim was properly backdated to the Sunday prior to her job separation. With regard to the job separation, the claimant took approved leave to attend a funeral. The claimant was separated because she was required to quarantine due to the pandemic following the funeral. The claimant's job separation was due to the pandemic. The subsequent offers of work in May and June are not relevant to the job separation in April. The May and June offers of work are issues of suitable work. Modify the AT valid claim, no voluntary leaving, no chargeback, and disaster.
The AT decision is not supportable. Claim records and AT testimony indicate that the claimant met the earnings criteria for being partially unemployed at the time of her claim, but her claim should be backdated to April 19, 2020, since the most credible evidence shows that she worked until April 22nd, 2020. The Commission would have the jurisdiction to backdate her initial claim to April 19, 2020, because the date on which an individual becomes unemployed, a validity of claim issue may be redetermined at any point in a benefit year. Regarding the work separation, the disqualification originally imposed by the claim investigator should be reinstated. The claimant made it clear that she took a voluntary leave of absence during a period in which continued work was available. She did not have good cause connected with the work for doing so. Furthermore, she did not respond to the employer's repeated attempts to persuade her to return to work. Accordingly, we should reverse the AT decision. The claimant filed a valid initial claim, backdate the initial claim to April 19, 2020, voluntary leaving, no chargeback.
Reverse the AT, valid claim, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez. Oh, and just for clarity, Mr. Chairman, do you agree with the back date of April 19th, 2020?
Yes.
Thank you, sir.
Case number 2628888, Commissioner Alvarez.
The decision is not supportable. The claimant has custody of her grandchild and was separated when her grandchild broke both legs. The claimant had to stay home and care for the child. The claimant called the named employer and the client company to report her absences, but was discharged due to her excessive absences. The claimant's absence due to her minor child's injury was not misconduct. Reverse the AT, no misconduct, void chargeback.
AT decision should be affirmed. The claimant stopped working to care for her granddaughter, which is a personal reason. At present, the record in this case is insufficient to qualify the claimant for benefits pursuant to any exception from disqualification provided for under the Act. As such, we should affirm the AT decision, voluntary leaving, void chargeback.
Modify the AT, no voluntary leaving, urgent and compelling, void chargeback.
Okay, we have not yet achieved a majority vote. We do have a majority to pay the claimant, but the basis for that payment is not determined.
Ms. Miller, I would agree with Chairman, no voluntary leaving, void chargeback.
Thank you, sir.
Yes, sir.
Short form dissent.
Yes, sir, Commissioner Demerson, I have your dissent.
Case number 2628949, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The claimant quit his job because he was fearful of COVID-19. However, the employer stated that it was taking precautions at the workplace, including temperature checks and providing masks. The employer also stated that there was work still available. Accordingly, since the claimant quit out of fear of COVID-19, the circumstance that by itself would not provide a basis for having good work-connected cause to quit, he should be disqualified from benefits. We should therefore reverse the AT decision, voluntary leaving.
The decision is supportable. The claimant separated from work due to concerns regarding the pandemic. There had been cases of infections at the workplace. The claimant's concerns were founded as the employer later had to close facilities due to the pandemic. Affirm the AT, no voluntary leaving.
Reverse the AT, voluntary leaving.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2630365, Commissioner Dimerson.
The appeal tribunal decision should be affirmed. The claimant quit due to dissatisfaction with the workplace. Specifically, the claimant felt she was not getting paid all the hours she was owed. However, the employer took action to remedy the claimant's concerns when she brought them to the employer's attention. Despite the employer taking action to rectify any alleged discrepancies in the claimant's pay, the claimant still resigned, feeling she was owed more money. The claimant has not provided any corroborating documentation to establish that she was owed more money than what the employer provided after her concerns were addressed. Since both parties entered the hearing with equal credibility, the claimant would have the burden of establishing the preponderance of the evidence that she had good cause connected with the work for quitting. The claimant has not done so. Accordingly, we should affirm the AT decision, voluntary leaving, no chargeback.
The AT decision should be reversed. The claimant was shortened $1,200 by the employer on 2 different paychecks. She reportedly tried to have the mistakes corrected with management, but she was never given her full pay for those pay periods. She resigned as a result. Since the claimant made repeated repeated attempts to have her pay corrected, she had good cause connected with the work to resign when she still did not receive the corrected pay. Reverse the AT, no voluntary leaving chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2636305, Commissioner Alvarez.
The decision should be reversed. The claimant was promised 55 to 60 hours of work per week when she accepted the job. The claimant was only receiving 32 hours a week. The claimant spoke with his supervisor about the reduced hours, but the supervisor was unable to say when it would be busier. The claimant gave the employer a reasonable amount of time to resolve the issue with the hours. The approximate 50% reduction in hours, which resulted in more than 50% reduction in pay, gave the claimant good cause connected with the work for quitting. Reverse the AT, no voluntary leave.
I would agree that the claimant separation was the result of the disaster. We should reverse the AT decision, no voluntary leaving, disaster.
Reverse the AT, no voluntary leaving.
All right, we have a majority vote to pay the claimant, but not a majority vote on the rationale. Let's see, Commissioner Alvarez based it on the reduction in pay, and Commissioner Demerson based his vote on the disaster.
Reduction in pay.
Thank you, sir.
In all short form, Chair.
Yes, sir.
Thank you.
Case number 2643991, Commissioner Alvarez.
The AT decision should be reversed. The claimant was called by the employer to return to work sometime after May 25th, 2020. She asked to come back on or after June 1st, 2020, because she was responsible for providing homeschool assistance for her autistic nephew, whom the claimant raises. She also needed time to obtain protective equipment that the employer refused to provide. The employer refused to allow the claimant to return 1 week later and withdrew the offer to return to work. Under Commission COVID-19 guidelines, an employee will not be disqualified for refusing to return to work if the employee has to care for a minor child whose school is closed. The claimant was required to stay home with her nephew until his at-home school year ended. She would not be disqualified for refusing suitable work under Commission guidelines. In any case, the claimant did not refuse the offer of work. She merely asked to return 1 week later. Reverse the AT, no suitable work disqualification, no overpayment.
The appeal tribunal decision should be affirmed. Per the employer's work refusal documentation forms, the claimant was offered suitable work in line with what she had been working previously, which included the same wages, hours, and working conditions. Nonetheless, the claimant rejected the work due to personal reasons. As such, we should affirm the AT decision, suitable work disqualification, overpayment of $2,310.
Reverse the AT, no suitable work disqualification, no overpayment.
Reform.
I have your dissent, Commissioner Demerson.
Thank you.
Case number 2648363, Commissioner Alvarez.
The AT decision should be reversed. The employer made a payment to the claimant that was 6 months of her salary. In exchange for the payment, the claimant signed a release of claims, confidentiality agreement, and a non-compete agreement in which the claimant agreed not to work for the employer's competitors for 6 months. The claimant made significant concessions in exchange for the payment, one of which was her ability to find gainful employment in her field. Given the non-compete agreement that the claimant was required to sign in order to receive the payment cannot be considered disqualifying severance pay. Reverse AT, severance pay eligible, no overpayment.
The appeal tribunal decision should be affirmed. The claimant received severance pay. Did not provide any testimony to establish that such pay fell into one of the non-disqualifying circumstances in 207.049B of the Act. While the claimant seems to indicate in a fact-finding statement that the severance pay was given in exchange for release of claim or as the result of a settlement agreement, there is no further elaboration or detail about a pending claim that the claimant had against the employer in connection with the employment relationship. In the claimant's fact-finding statements, she disclosed that the severance pay covered 26 weeks, and accordingly, the disqualification period provided by the appeal tribunal is supportable. We should affirm the AT decision, severance pay disqualification from June 14, 2020 through December 12, 2020, overpayment of $1,042.
Reverse the AT, no severance disqualification, no overpayment.
Was short form?
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2664140, Commissioner Alvarez.
The decision should be reversed. The Texas Workforce Commission stated repeatedly on Twitter that unemployment claims would be dated when the claimant was affected by the pandemic. Executive staff also gave interviews stating that we would use the last date worked as the basis of the claim instead of when it was filed. To prevent injustice, Rule 22 should be applied to this claim. Reverse the AT valid claim backdated 6/28/20.
The appeal tribunal decision should be affirmed. The claimant delayed filing her claim for benefits because she was unaware that she needed to do so. Not being familiar with how or when to file an unemployment claim is not a good cause to backdate a claim. Accordingly, we should affirm the decision, backdating denied.
Affirm the AT, backdating denied.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2684500, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant worked as a substitute teacher for a school district where teachers were responsible for searching and choosing their own assignments. There would have been work available for the claimant had she been signing up for assignments, since assignments were unfulfilled every week. Because the claimant initiated the job separation by no longer taking assignment, and there is no indication that the claimant's quitting was for good cause connected with the work, the employer should not be billed. We should reverse the AT decision, reimburse an employer, not billed.
The decision is supportable. The claimant was an on-call as needed substitute teacher who stopped working at the end of the employer's 2019 school year. The employer has not provided any evidence to establish the claimant was discharged for misconduct or voluntarily quit without good cause. Affirm the AT, bill reimbursing employer.
Reverse the AT, reimbursing employer, not bill.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2685591, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant separated from the employer when she requested to transfer to another of the employer's locations. The claimant requested the change because she was unhappy with the way her manager had handled the guest matter. When the claimant brought her complaint to the management, the employer investigated. There is no indication that the employer failed to address the claimant's complaint. Because the claimant quit when she voluntarily transferred to another location, and the record did not establish that the claimant had good cause connected with the work for quitting, we should reverse the AT decision, no chargeback.
The decision is supportable. The claimant separation occurred after she was transferred to a new employer account number. Although the transfer was at the claimant's request, it was done because of the claimant it was done of a complaint the claimant had made against the manager. The employer had received complaints against this manager in the past. The employer would normally approve a transfer, but did so because of the complaint. As the employer found the complaint sufficient enough to override their own policy, it appears the claimant had good cause connected with the work to transfer. Affirm the AT, chargeback.
Reverse the AT, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez. And that was the last case pulled for additional discussion on docket 4. I previously sent you the UI short form dissent list for docket 4.
Chairman, if I may interrupt, and I apologize for this, but I do have a question on one of the past cases. I wanted to see what your decision was on one of the cases. If we can go back, Ms. Miller.
Certainly.
The case is 2609471.
One moment.
2609471.
That was the third case. Is that correct? It's, if you don't know, that's fine.
Yes.
Two-
Yes,
two-
it is. It is.
Okay. And what was your question?
So I wanted to know what the results were from both Commissioner Demerson and Chairman Daniel.
Commissioner Dimerson and Chairman Daniel formed the majority. The claimant left work with good cause connected with the work based on the disaster, severing the validity issue.
Okay, I would agree with both the chairman, and I'd like to change my result to decision as, and agree with both chairman and Commissioner Demerson.
Thank you, sir. We've got a unanimous decision.
Thank you. Thank you, Chairman.
Of course. I move we accept staff recommendations on the remaining UI cases on docket 4.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form list for docket 4.
And I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 4.
Motion passes with the exceptions noted.
Thank you, sir.
Thank you. This brings us to the end of agenda items 3 through 7. I see Mr. Cerna. Mr. Cerna, do we have an executive director's report today?
Very brief one. I want to make sure the commissioners are aware that I did conduct an all staff, all agency meeting last week using technology. One of the upsides of the COVID pandemic is we've increased our use of technology and was able to hold a staff meeting with all of our staff. There were about 4,200 staff that signed on to the live event, and so far about 700 have looked at the recorded event. We had a few little technical glitches that we'll continue to work through, but it is a good way for us to communicate information to all of our staff at one time. And I intend to repeat it perhaps at least once a year, maybe twice a year, just to keep our staff informed about what's going on in their agency. So that's all I had to report to y'all.
Thank you, Ed. Actually, I think that's a phenomenal exercise and one that I'm glad you undertook. I know there were many staff very interested in what you had to say, and that's the ultimate open door policy when we can use technology to get the executive director agency-wide. I really appreciate what you've done there and appreciate all you guys are doing to keep everybody abreast of the pace that we're keeping here at TWC, both with regard to the pandemic and all the other work that we're doing as well. So much appreciated.
Yes, sir.
I agree with you, Chairman.
And
And while I got you, I had a couple of requests, if I could make those now.
Yes, sir.
One is, at the next commission meeting, could we have our staff update us on all the different measures we've taken with regard to COVID, all the pandemic-related measures that we've taken? Just give us a general update on where we are with those. Some have completed, some are in progress, like our skills enhancement efforts. I would just like a picture of sort of what we've done and where we are and what things are continuing into the future. I think it's useful for us to revisit that from time to time.
Yes, sir. We'll do that.
Yes, sir. Thank you. And then the second request I have is, could you ask staff to provide a briefing to my office on where we are with both WIOA and TANF funds that have been encumbered, obligated, or otherwise promised, but not yet expended, so I can get a picture of some fund balances and what projects will be occurring over the remainder of this fiscal year based on those encumbrances and obligations.
Yes, sir. We can do that.
Thank you.
Probably won't take us more than a week or two to be able to do
Okay.
that, and then we can
Perfect.
share the same information with the other offices.
Absolutely.
Thank you, Ed, and we would appreciate the same. If
Yes,
we
sir.
could have
We
a
will do
briefing
that.
on that as well.
Yes, sir.
Good
Absolutely.
idea. Great idea.
Great. Well, thank you. Thank you, Mr. Cerna. Is there anything else for Mr. Cerna?
None here, Chairman.
Chairman, I was going to say, Ed, the Ask Ed went over very well in terms of the questions. And so you mentioned doing it once a year or twice a year might be, it was hot demand, hot item. And so I know a lot of the members really appreciated you reporting out. So.
Yes, sir. We got 80 questions or comments. I'm looking at all of them, and we're gonna provide responses to all of them because we were only able to do about 8 of them in the event. I didn't want the meeting to take that long, but we will get answers to all of our staff. So thank you, sir.
Ask Ed. So.
With that kind of response, we may see Ask Ed on YouTube soon.
Yeah, Ask Ed. So.
That will not be the case.
Is there any other
Thank
item of business that should come before this commission?
None here, Chairman, except for all of us to have a great weekend.
Absolutely. Do we
Or
have
great
a-
week, I should say, great week.
Do we have, I wish it were the weekend, Commissioner Alvarez. I really do, but we got, what, 4.5 more days of this work. Do we have a motion to adjourn?
Chairman, I move that we adjourn.
I second his illustrious motion. So.
It's been moved and seconded to adjourn, and we are adjourned. Thank you, everyone.
Have a good weekend, a great week.